People's Democratic Party in Edo State has applauded the ruling of a high court sitting in Benin City, which granted the application to reinstate the chairman and vice chairman of the 18 local government areas, who the party said were illegally and unconstitutionally suspended by the Edo State House of Assembly at the behest of the governor, Monday Okpebholo. In a statement signed by Dr. Tony Azebami, the chairman of the party, he said the court in the ruling also directed the defendants, including the Edo State government, the governor, and the attorney general, among others, not to give effect to the House of Assembly resolution purportedly suspending the 18 council chairmen. Azebami said the landmark decision was a victory for the Edo people, democracy, and the rule of law. He said, "We consider this ruling timely and particularly significant as it will help restore hope in the people that the judiciary still remains the last hope of the common man, especially as the tribunal proceedings on the 2024 governorship election continue, where the PDP is resolute on reclaiming the mandate overwhelmingly given to it by the people of Edo State." The PDP chairman urged the local government chairmen to return to their offices and continue their work of advancing grassroots development and the delivery of impactful governance for the benefit of their communities. He urged all stakeholders to respect the court's decision in the interest of peace and in compliance with the rule of law. He also called on the police and all security agencies to come out in their full regimen to protect the local government councils and the chairmen, ensuring they can effectively carry out their constitutional duties and responsibilities. Why were you smiling when I was reading this story?
You know, this is Nigeria, and as the barrister is seated here, when the judgment tends to favor one, it's Uhuru, and the judiciary is the last hope of common man. When it turns out the other way around, the person begins to vilify the same judges, not knowing that judgment should not be preempted. The suspension of the 18 local government chairmen in Edo State was an affront on our constitution. If the governor wanted to do that, he has a way of doing it. He would have gone through the councillors. You know, this overtime of the governors having enveloped the chairman and being those people who handpick them, they are subservient and most of their errant political boys. So there is a sense to which the governors control them, but Governor Okpebholo has forgotten that he's not the person that got these people through their electioneering time, and their obedience to him is what he wants to, make them understand that a new sheriff is in town, but he has gone about it the wrong way. And again, because of the landmark judgment of the Supreme Court on the local government financial autonomy, the presidency frowns at this particular move and has condemned it through the Attorney General of the Federation, in as much as some APC stakeholders in Edo State has also pointed out that the state House of Assemblies also have the inherent right, according to the Constitution, to make laws governing the local governments. So, but be that as it may, this particular suspension was hasty. Some other people do remove and they ask them to be going to court. If he has done that, there should have been a sense that he has also come into the fray as using the draconian law of the governors in removing some of those local government chairmen they did not produce. But because of that judgment of the Supreme Court, he was a little skeptical on not knowing what to do. If I remove them totally, there will be a backlash. Let me suspend them for 2 months. Who gave you that kind of constitutional power to remove an elected officer? If you want to do that, you have gone through the normal process of buying over the councillors who constitute their own local legislation to be able to institute an impeachment or a suspension procedure against their chairman. But he has gotten the backlash that he needed. Now, PDP quickly went to court because all those chairmen are PDP members. That's what we see in Nigeria. Any sitting governor that conducts election wins it outrightly. So the PDP have taken it as a witch hunt. And they are not taking it with kiss glove now. They have gone to court and there have been a court judgment. In the first instance, there would have not been a room for the court to tell the governor what is right to do. But because the governors think they are emperors and they have this immunity that covers them, they don't know that the immunity is only for them not to be taken to court, not that cases will not be instituted against them. But at the end of the day, they are now using it to, to usurp a lot of powers around the state. But we are happy that the court has done the needful and the federal government has also reacted. So let Okpebholo begin to look for another way around or wait for their 3-year tenure to expire in order to put in his own APC, those that will be subservient to him. I think that's my submission.
All right, very well. You said a lot around judiciary and political motive of the governor. Now, yeah, he talked about his political motive.
I'm to even taking back to our previous discussion where we said the national interest of the political party should have taken supreme over judicial power.
At this point, I want to hear what you have to say. But I also must ask you a question. Can a democratically elected local government chairman in this instance, can they be suspended?
The Supreme Court has held in a plethora of authorities.
Go ahead, Jamala.
That the governor has no power whatsoever to even suspend an elected local government chairman.
In this instance, Okpebholo said he did not. It was the House of Assembly.
I agree. See, Section 7 of the 1999 Constitution places the State House of Assembly powers to make laws for the governance, administration of local governments. That's where our problem lies. It's not even the Supreme Court decision
so they are putting
of financial autonomy.
Yes, they are now putting the House of Assembly, local government, Edo State's House of Assembly, local government law.
Yes.
But if it is an aberration,
fine, that is where the court came in. Right. We have that law in Rivers State. In 2018, the then governor, yes, on Wike, through the instrumentality of the Rivers State House of Assembly, enacted the Rivers State Local Government Law number 5 of 2018. Now, there is a section in that law that gave the governor the power to suspend an elected local government chairman. He can suspend and thereafter ask for the ratification from the House of Assembly.
I think it's time we start asking Algon what they are doing exactly.
Who has challenged that law?
What is Algon
that
doing?
Provision. Who is Algon?
That is very draconian.
Algon to me and you. Algon are persons we called subservient. Persons governors picked.
Yes, that's what we see.
To empower. And so they will not even have the guts
to fight in the interest of the local
now government. We have financial autonomy in quote. So that is where state governors are beginning to, if I do not have, look at before the last local government, the Rivers State local government chairman left, some of them became emperors. Right? To the extent that they were not even receiving the finance directly from FAC. But they became emperors to our governor. Then, if these local government chairmen were receiving their finances, allocation directly from the federal government, don't you think we will be having different states in Rivers State in the name of local government? But Section 7 has placed their powers on the control of the state. So you may have the financial autonomy. It is the State House of Assembly that will direct how you spend our resources through a law that will be signed by the governor. So you can have your billions, the state will come out to say you will not spend more than 500 million a month. And it stands because that is the power of the State House of Assembly to do so. Now, until that law is set aside, which the court, the restorer of hope, the court is the restorer of hope, has come to do in the circumstance. So that's why I said if our court will sit right, ordinarily, if it will be a judge whose mind is biased, tilted to favoring the governor, the institution in power, using, let me borrow his word, federal minds. The governor would have said, but that is the provision of the local government law of the state. Then maybe we'll test it at the Court of Appeal. So the inconsistency in that law and that of the Constitution is what made the judge to nullify that suspension. So it is not.
So if a House of Assembly makes a law that is not in line, in tandem with Nigerian Constitution,
until it's challenged and pronounced.
Until it's challenged,
yes, it is the court.
Effect.
Yes, it is the court that has the powers to pronounce that law null and void, not you and I. So if a House of Assembly has made a law and I do not like it, I am bound to obey it until I challenge it at the court of law.
And have it
set aside.
Yeah, like, all right, very well.
So for Rivers State, it's still existing. So tomorrow the governor can wake up and suspend one.
Because he has the power to do
The state instrument gave him that power to do so. And that instrument is, whether it is inconsistent with the Constitution, for now, the court have not said so. So until challenged, until challenged and the court said so, then that power is removed from the governor. And that provision that gave the power, the Constitution, that right to suspend is expunged from that law. You remember in 2024, yes, Amewule and co enacted local government law, number 3. Number 3 of 2024. In that their law, they made some provisions of the law to usurp the powers of the governor and arrogate it to themselves. It was challenged. My Lord, Honorable Justice Q.
Can you state what the provisions of that law was?
One of the provisions I can remember is that of the extension, elongation of local government chairmen. That the House, by a resolution of not less than 2/3 majority, can extend the power, the local government tenure. It is not in the Constitution, please.
Go ahead.
Can extend the power, the local government tenure of a local government chairman. They relied their own understanding in the provision of the Constitution where Nigeria is at war. The National Assembly is at war, and it is impracticable to conduct election. And the National Assembly may consider or extend the tenure of the president for a period not exceeding 6 months. Was Rivers State at war in the circumstance? And that was not all. They said where the governor refused to swear these persons in after they have so done by a resolution, they can also appoint a judicial officer to take on that executive functions. And my Lord Honorable Justice Q was not didn't waste time to say that provision was against the executive functions as enshrined in Section 5 of the 1999 Constitution that places it on the governor of a state. Your own is to make laws. Leave executive functions for the governor. And so the governor cannot, by an executive order, also remove the powers of a state House of Assembly to create law, to enact law for himself. No, he cannot do so. So we thank God the State High Court has...
But you are aware that in the federal, the judgment of the Supreme Court,
yes,
under this financial autonomy, page 16, I think, yes, page 16 of that, of the CTC of that judgment, the Supreme Court stated that the local governments, the state houses of assembly, actually have the right to extend the tenure of local government chairmen. The Supreme Court said that.
I cannot sit here and confirm that
I'm trying to get that.
I know you are paraphrasing, yes, until you get... Shoma, if you show it to me, that because the issues that were before the Supreme Court with respect to financial autonomy has nothing to do with elongation of powers.
That was discussed. That was the Supreme Court.
We discussed it on this
Supreme Court
this
talked
platform.
About it. I think I did a series on
yes,
that particular judgment.
Yes.
That's because everybody was on.
Shoma, if you show it to me, I will go through it.
But hold on. Everybody was fixated on the local government financial autonomy, that nobody was looking at that section of the judgment. And when I stumbled on it, I was like, wait, nobody's looking at this section of the judgment. And I discussed it. I did a series on that judgment for 2 weeks consecutively every day. So I'm trying to get it for you. I'm going to get it for you. But I am aware, 100 times aware, that the Supreme Court, when they were giving that judgment in July, also talked about extension of the tenure of the local government chairmen. I am aware of that.
Why you have 1 million rights?
It's here. Let me quote it. All right. It says, I am quoting it.
Yes, read it.
Under section 135, subsection 3 of the Constitution, the tenure of 4 years for the president provided for by section 135, subsection 2 thereof, shall be extended for periods not exceeding a period of 6 months at any time by a resolution of the National Assembly, if it is not practicable to hold elections. By same token, by a law of a state house of assembly, the tenure of local government councils can be legally extended for any reason, such as insecurity or war, if it becomes impracticable or impossible for elections into the local government councils to be conducted. The mandate given to an elected local government council is the mandate of the electorate of that local government area. And if the tenure is extended, it is the people's mandate that is extended. If the tenure of a local government council is truncated, as it is the norm now, it is an illegal termination of the electorate's mandate, and it is not to be encouraged, but roundly condemned. This is the Supreme Court judgment.
Yes.
And this is on page 16.
Read the last paragraph of what you just read.
It said, if the tenure of a local government council is truncated, as it is the norm now, it is an
In which case is that?
It is, I am quoting the Supreme Court. I am quoting the Supreme Court judgment. So, it said, hold on. As it is the norm now, it is an illegal termination of the electorate's mandate, and it is not to be encouraged, but roundly condemned.
Fine. Chairman, until I read the complete set of that judgment, I will be able to understand whether it was an obiter or it was a ratio of a court.
It was a judgment.
I agree. In a judgment, we have what we call ratio. We have obiter dictum. So until I read it, because the one for River State was challenged at the Court of Appeal, and the Court of Appeal also agreed with the River State High Court.
That was done. It was done before the Supreme Court judgment, wasn't it?
I cannot remember.
It was done before the Supreme Court
judgment. I cannot remember. Now, there are authorities are made for its own selves. You must apply them, whatever. I want to know the facts of this case. To the extent that, because I'm fully aware, I have the processes of the Honorable Attorney General of the Federation that challenged, that brought about the decision of the Supreme Court with respect to financial autonomy.
Go and read that.
I have it.
Look for page 16 of it.
I have it, don't worry.
Go to page 16.
I will look for it. I'll read it.
All right.
I'm also aware that the issue of illegal termination of tenures of local government has been settled by the Supreme Court. That a state House of Assembly or a state governor lacks the powers to do so.
Because they're elected.
They're elected. But the issue of elongation, to the fact that, one, there is war, two, insecurity.
Where there is impracticable.
What makes it, what qualifies that impracticability is what they have looked at war and insecurity. Aside these two.
No, they said for any reason. Then
for any reason such as.
Hold on. For any reason.
Such as.
Such as.
Yes.
Now, it means that, for example, not limited to. It is not limited. For any reason, usually gets the
I agree. But what qualifies a cogent, verifiable reason must fall within a line of this.
When it becomes impracticable.
That's what I'm saying. What qualifies that impracticability? First, they have given you an example, insecurity.
An example doesn't mean that it's limited to them.
I'm coming. They have given you, for whatever reason you are giving, it must fall in line with these two. It must fall in line. Assuming the state does not have the resources, and who conveys that information to the assembly to do so? Assuming the state does not have the resources to conduct the local government, it is a reason. Is it not?
A reason.
Then they can now elongate.
Who communicates that information?
Now, which means that it still boils down to what we are saying.
Yes.
for any reason, number one, there is an underlining statement. I think there is a functional statement, which is for any reason. It is now the prerogative of the court.
Let's not belabor ourselves with this issue.
No, hold on.
You will have me back.
You will not be the one to tell me not to be labor.
No.
I want to be labor myself.
Oh, yeah, labor now.
I want to.
I don't belong to the Labour Party.
I do not belong to any party. But right now, I want to be labor myself heavily on this, because the truth remains that, I mean, isn't this part of the issues going on, I mean, across the states? Edo State, for example.
Yes.
Do you understand? That was why, you know what led to this conversation is, yes, the state houses of assembly are saddled with the responsibilities to make laws for the local government.
Yes.
Now.
But those laws must not be inconsistent with the provisions of the Constitution.
Hold on. And yes, we also discussed that.
But you said where it is, if it had not been challenged,
yes,
it remains. That's what you said too.
Yes, that inconsistency must be pronounced by the
but if there is inconsistency, and like in River State, and they have not been challenged, it's allowed to flow.
Opportunities
that's
are not.
What he's saying.
That's what he said.
That's what I'm saying. Yes.
So now,
but that is a law.
Given by that, what actually brought up this particular conversation was you were saying you now cited River State House of Assembly law,
yes,
that you said arrogated some
local
powers.
Government law number 3.
Yes, that arrogated the powers, some of the powers of the executive to itself, and it was struck out by courts.
Yes.
And that was what brought out this particular one, to remind you that there is a Supreme Court judgment. So probably the River State House of Assembly for now have chosen not to actually appeal that. Probably if it is appealed,
they have. The matter is before the Supreme
probably
Court.
This issue will now definitely, I am sure this issue will fall back to
then the issue, the reason that they are giving, whether it will justify the enforcement of that powers. Right? The reasons that they will allude at the Supreme Court is what the Supreme Court will look, whether it falls within the contemplation of that particular law. And remember, Section 135 is only as to national laws, not as to state local government laws.
You see, before we flip this Edo issue, I'm just baffled about it, because a PDP governor just exited the office, and the governor, Okpebholo, is using the PDP majority House of Assembly members to now oust their brothers, which are the local government. You could see the nature of politics we play in Nigeria. But Sir Jamala, I don't know if you understand what I'm trying to say. The governor...
You should refer to what Akpebholo had said when Akpebholo was speaking.
Okay,
Akpebholo said that every matter, when he was governor, he also made sure the speaker was always close by him.
Okay, I discussed it last Sunday.
Just like the president,
so that he will look at his face and know if he's happy with him, and know that he's safe. You know, Akpebholo said, I think I discussed it last week here. But where the governor can now, within 3 weeks or a month of his tenure lifetime, to, you know, be able to synergize with the State of Assembly being majorly constituted by PDP. It beats my imagination to now puncture the PDP structure. You know, this local government is the structure. You know, to puncture the PDP structure heavily. Because once these guys are being suspended, there is a sense of that fear being instilled in them to either be prey or to be so fragile that the APC could start poaching them. You see what is happening in the National House of Assembly, that look at my friend Dauda Matthew, who won the one they called the Okada man in the national in the green chambers, has cross-carpeted to APC from Labour Party. But he won election on the benevolence of the people. That the people, he wants somebody who has gone to the house 4 times. I did masters with him in Abuja. He's from Kaduna State. The guy they call Okada man is not Okada. He's a philosophy BA degree holder. But the only thing is that he was using that thing to augment according to the Nigerian system. But look at him now, who won freely according to the mandate given to him by the people. He has cross-carpeted in order to secure his political seat, jettisoning the people. What does that tell you about the elections that we conduct in Nigeria? That means the people have not much say.
All right.